Please continue to hold. Please continue to hold.
We're going to find out, guys. What's going on? Morning, Allison. I think I just saw you pop in.
Please continue to hold.
So, we're sitting and waiting. This should be a very, very contentious hearing. Maybe. Who knows? I mean, I shouldn't speak ahead of time.
Please continue to
This
hold.
could be a very contentious hearing. There is going to be someone there this morning from ICE. Let me see if I can do a little bit of work here to make this, clean this up a little bit.
Please continue
I know,
to
the
hold.
CVS hold music. Well, and the other thing is, guys, so it's 11:30. It should be starting right now. And there is not a public call-in number for this. Sometimes there is, sometimes there isn't. I found a call-in number, and it's worked for me for a couple of calls, a couple of hearings. It may not still work, and I've had it happen where you just are stuck on hold forever. We only just hit the time that the hearing's supposed to start, so... Your call is
Please
important.
continue to hold.
But there's always a possibility that they decided to close this off, and we're just going to be sitting listening to hold music forever. Hopefully not. Make sure I've got my... Where is my... Oh, there we go. We are on hold because the hearing has not started yet.
Please continue to hold.
So the hearing was set to start at 10:30 a.m. Chicago time. I'll tell you what I'm going to do here for a minute. Let's see. Let's see if there's an easy way for me to do this.
Please continue to hold.
Well, I wanted to try to show you something, but it does not seem to be following the screen as I move it. Let me see if I can get it to.
Please continue to hold.
Alright, so I'm going to show you guys for a second. I can't see what you're saying, I apologize, but the only thing that was filed, well, over the weekend, it looks like they filed a notice of distribution of the modified temporary restraining order. So the government filed something saying, hey, we saw your new TRO and we have distributed it. And this is the exhibit of us distributing it via email to everybody because the judge demanded that they do that.
Please continue to hold.
Here are the people that are going to be at this hearing today. So she had said that she wanted Hott, whatever his first name is, Russell Hott. But apparently he has been moved. So instead they are providing us with Deputy Incident Commander Kyle Harvick and Deputy Field Office Director Sean Byers. They are supposed to be coming in to testify on exactly what ICE agents have been told in Chicago this TRO orders them to do or not to do.
Please continue to hold.
But the thing is, she did not ask for these guys. She asked for someone else. So we will see if she is unhappy with that choice. But my guess is they wouldn't have gone that far away from her order without talking to her first. You never know. But it's unlikely.
Please continue to hold. Please continue to hold.
No, we're just sitting here.
Please continue to
I'll
hold.
give them a little time. And see what happens. Sorry, let me get over to... it was supposed to start 7 minutes ago, but...
Please continue to hold.
We're just going to have to find out. They may have just decided not to stream it, especially if they showed up. If everybody's in court today, you know, previously somebody's always been in from an outside location. So
Please continue to hold.
Morning report is just up a few minutes ago. I just barely got it up in time. And of particular interest,
Please
I'm going to
continue to hold.
turn this down for a second, is something that, was sort of kind of brushed over. But there was, one of those cases that was kind of ignored, it was rejected by the Supreme Court on Friday. But it came, and sometimes a case will be rejected not because the argument's bad or because it's not something they want to discuss, but because the way they have the facts, the facts of that case just aren't the right ones that they want to decide this thing. And so they'll say, nope, not this one, but maybe another one about this. And this is one of those cases. It's I forget the name of it off the top of my head, but it was rejected on Friday. But Justice Gorsuch added a little note to it, and he said, basically, I think it's time for us. This is 100-something-year-old precedent that I think we wrote before we had really hashed this and thought this through. I think we need to take another run at it. And the question is whether or not the 7th Amendment applies to the states. Because in 1916, when the precedent was written, we weren't really applying the Bill of Rights to states. That was kind of a new thing. And so Justice Gorsuch says, you know what? I think, if we didn't really get into applying the Bill of Rights to states under the 14th Amendment until they did like one before this, but really the ball didn't get rolling until about 1925. And then from there, we really have heated up since then, and we really add a bunch. Yeah, we're still waiting. And so he said, I think it's time for us to look at the 7th Amendment again and see if it's time to apply the 7th Amendment to states, because it's because juries are so important, and we need to reconsider whether or not we are going to require states to provide a jury in civil trials. So I think it's a really big deal. I think it's a very important one, even though it's just a little side note. So they did not take the case, but that could be for other reasons. And it could just be that, I will say that the particular case might have been it was an iffy example. It wasn't like a classic civil case. It was more someone was getting what do you call it? Like administrative fees. They were getting zoning infractions kind of thing. Like, I don't know if it was zoning, but it was something like that. It was like a board that was giving them fines for breaking some sort of regulation, and if you wanted to appeal those fines, you went before what was the equivalent of a judge and jury, but the entire judge and juries were other zoning people, other people from that board, basically. So it's like you're gonna lose, is what the plaintiffs say. And it's just not. I mean, the court may have wanted a different case. They may have wanted a different set of facts in order to argue this. And sometimes that's what they do. Sometimes they wait for just the right set of facts so that they can write the opinion the way that they want. But he was kind of putting all of the lawyers in the country on notice that this is an issue he wants to talk about. And we should, if you've got a case sitting on your desk that you're thinking about bringing, now's the time. So that's pretty cool. Let's see here. So I'm not going to give this forever, guys. I'm going to give it a little bit more time, because there is, like I said, there's a possibility that they just decided not to broadcast this. And I've now been sitting here I got in early, so I've been sitting here for, every time it goes quiet, I'm like, oh, no. Tell you what I could do. I'm going to log out and log back in again and see because you never know.
Enter your access code or meeting number followed by pound. The meeting is not started yet.
Yeah.
If you are the meeting host, enter the host PIN followed by pound. If you are not the host, press pound. Enter your attendee ID number followed by pound.
That's the other possibility
Host
is,
did not join the meeting. Please stand by.
well, no, they say the host hasn't. So yeah, they may just not be putting it up, or they might be having trouble. You know, the first time I came in here, it took them like half an hour to get the equipment working. So let's see here of how. What makes for a good example case? Often the court will look. Let me think of what I'm trying to say here. Often the court will, you know, if they want to make a rule, if they want to make a big rule that's going to stand for a long time, they don't want to make it on a set of facts that still has questions. And I wish I could think of a better way of saying that. They usually try to find like an extreme set of facts that doesn't come up very often. Okay, so there was a case where the court needed to rule on the right of students to protest in school.
Please continue to hold.
And when students can and cannot protest in school. And they wanted to set up like a pretty solid rule, and the situation they ended up using is one where the students who protested came into school with an armband on and did not say or do anything else the whole day. That was the entire protest, was just they were wearing an armband throughout the day. And the court was able to say that is 100% allowed. And when they can say what is 100% allowed based on the set of facts, then from there we can start working out, you know, hashing out the stuff in the middle. If the case had some more, you know, if there'd been, you know, a couple of them had interrupted their classes or knocked over tables or something like that, then the court has to say, well, it's okay if they do this, but not if they do this, or okay. They don't want to do that. They want to say, this is 100% okay all the time. And let everybody else, you know, the lower courts and stuff, hash out the situations where things are a little bit less clear. And so that's an example of something that they'll look for, is a situation that is just so clearly, you know, a First Amendment violation or not a First Amendment violation, that they can set a rule that is a good, solid red line. But they got to find the right set of facts for that. And so sometimes they will pass up several cases that are very similar, looking for just that right one. So that's an example of a case that the court will look for.
Please continue to hold.
And that would be a really good set of facts for them to respond to. I hope if that makes sense. Okay, good. All right, good. Because I know it's, you know, it's a little hard to explain. Like, what do you mean that a set of facts is perfect? What is it? But I think that's a really good example. You know, it's like you can go completely on one side. I need to find. I've lost my coffee mug.
Please continue to hold.
Somewhere in here. Though on state constitutional analogs of equal protection and benefit clauses, political gerrymandering. So So the court has addressed political gerrymandering in the past. I know, not the coffee. It's around here somewhere, and I have my like refill. I just don't have a plate. I might just dump it straight out of the court has addressed political gerrymandering, and basically the court's take on it is the kind of definitive court opinion on political gerrymandering, separate from other things, is everything about this is terrible. We hate this. Thank you, Justin. We hate this. This is terrible. We don't like this. This is bad. But then they go through kind of a series of explanations. Thank you very much, Justin. I appreciate it. They go through sort of a series of explanations as to why it's kind of out of their purview. And I off the top of my head, it's been a little while since I read it, but the general idea was something like, let me think here. I know it had to do with Congress being allowed. I think it had to do with some combination of states being allowed to set their own rules, and therefore it being outside of the purview of the federal government entirely, and Congress having the right to determine its own membership, and so any crossover, any place where the federal government, hey, Di, how's it going? Any place where the federal government was allowed to intrude, the court didn't think they were the ones to do it. But they go through this big long thing like, this is absolutely terrible. We hate everything about gerrymandering. This is awful, but this is not our thing to fix. Now, on the flip side, they have upheld, as a result, I think, of that case, they have upheld the rights of states and also of individuals in states, like, what do you call it? When people come together and write a piece of legislation and vote for it. I can't think of the word. Anyway, they've upheld their ability to the power of human beings, of citizens, to overpower the legislature if they're trying to gerrymander things. And the ballot initiative, thank you. If through ballot initiative the people of a state try to overpower the legislature, the Supreme Court has given them the power to do that, and said, even though the Constitution says it's up to the legislatures of the state, that people, citizens coming together to vote are the equivalent of a legislature. The representative republic model allows that our classic concept of a legislature to act in place of those people, but the people still get to vote on their own. And so they are allowed to outweigh. And so that was a pretty cool case. I think it's one of the Arizona cases. There are several in Arizona that all kind of happen. And it's always the people who are really, really strongly in favor of the kind of power of regular citizens to control the electoral process are kind of your classic conservatives. Alito, I don't know about Alito, Scalia, Thomas. These are big people who have historically been very much in support of citizens being able to control, citizens and states having more power over the electoral system than the federal government. So I'm kind of interested to see if one of these electoral questions makes it to the Supreme Court, whether one of these justices finds some way out of their prior things. No, John, Jacob, I don't think they're letting us in today. I had to give up on my mug because I think it's over there, so I just took it straight from them. Yeah, I'm just guessing, but I think that we're gonna have to wait for them to issue an opinion later today, which is not hugely surprising, I guess, because I've been sitting in here since about 11:15 or 10:15 their time.
Continue to hold.
Yeah, some states allow ballot initiatives and others don't, and so there is a whole chapter in my fun book on the law of democracy about what they call direct democracy, and that would be those sort of ballot initiatives and things, and just kind of what that means, and the state power to have them or not have them. I don't know why people aren't. They may have just decided not to do it. I don't think it has anything to do with capacity, because I was on the call before. I think they just decided not to broadcast this one. So I wanted to hear that too, but no, that's all right. So I'm gonna give them a few more minutes and then probably call it. Yeah, I would say that there is a lot of case law of governors and legislatures trying to fight citizen initiatives. They do not like them, and it's different in different states. There are some versions, and there is a. If I could have the words in my head, I would give them to you, but there is a very big difference between different kinds, and they're all words you hear and kind of I used to use interchangeably until I started reading about this stuff. It's not. Oh, it is right here. Let's see here. Let me see if I can find. But there are some where, members of society, citizens, are allowed to write laws and then put them up and vote for them. And there are some where the citizens are allowed to essentially demand that laws that have been passed by the government be brought before them to vote on. Where the heck is the table of contents here? Page 21.
Please continue to hold.
No. Oh, there we go. Initiatives and referenda. That's what I was looking for. The difference between an initiative and a government a referendum. So in an initiative, the voters write something, either a statute or a constitutional amendment. There's usually a signature requirement. And then either there's a direct initiative where the voters vote on it, or an indirect initiative where once the voters have created something, the legislators get to choose whether or not it passes. So that's one. And then a referendum puts laws enacted by the legislature before a popular vote for approval. And that can be called by a petition or by the legislature itself. So that is the difference between an initiative and a referendum, which are two words that I used interchangeably for a very long time. We're going to see, I think, several Supreme Court cases related to the National Guard. I think they're just kind of working their way up. Yeah, I think a lot of the legislatures and governors do not like voter-led initiatives or referenda. They take away the power that they have and the control that they have over that situation, for better or worse. I'm sure there is an argument somewhere that it makes it harder to, I don't know. I can't think of an argument, but I'm sure there is one.
Please continue to hold.
Otherwise, they'd be everywhere. 80% of 5 congressional districts to pass. Yeah, well. That is a lot, yeah. We are on, well, we were waiting to see if a hearing was going to start. I think I'm going to give up on it in a second. Because I think that they must have decided not to broadcast it today.
Please continue to hold.
They will release this on. They should release this on Pacer, unless there may be some. This may be under seal. I didn't think about that. So, tell you what, guys, I'm going to wrap this up for now. But do go check in on the check the morning report. Got some information in there, and
Please continue to hold.
I'll be back tomorrow.